Hi everyone. Today's video is about the problems that can arise when shareholders exit the business and the safeguards that can be put in place to avoid expensive and time-consuming litigation. My name's Adam Morgan. I've been a barrister for over 25 years and I specialise in providing legal advice and services to SMEs across a wide range of commercial sectors. Now, today's video is designed to provide an overview of a number of the key issues that business owners will have to consider around shareholding. In particular, the relationship between shareholders, together with a synopsis of the relevant company law principles that apply in this area. In startup companies, there is typically a large amount of optimism and excitement around the creation of a new venture, but that excitement is often tempered by a shortage of working capital. Consequently, when founders seek to attract staff, they often gift equity to those new joiners in order to make their remuneration package more attractive. During this optimistic period, people within the company tend to get on well, and little thought is given to what will happen if things do not go according to plan. In particular, the procedures that are to be followed in the event of disputes arising and the rights of shareholder leavers upon termination of employment are things that are typically overlooked. For this reason, it's common for startups to simply use the Model Company Articles of Association, which are the standard default articles a company can use upon incorporation. And perhaps most importantly, they often fail to have in place an appropriate shareholders agreement. Now, this situation tends to arise because the Model Articles of Association create a false sense of security. It's important to bear in mind that the Model Articles of Association do have significant limitations. For example, they contain no restrictive covenants and they provide limited restrictions on the transfer of shares, which as a business owner is something you might be anxious to avoid. So what then happens when the honeymoon period is over and issues arise with employees who are also shareholders? Well, when it becomes apparent that some of the initial optimism was misplaced and issues do arise with some of those new joiners, the termination of their employment can be relatively straightforward to deal with. I say that because if the relevant employment contract is silent on termination provisions, or where there is no written contract at all between the parties, there are statutory notice provisions that will apply to the termination of employment. So, although there may be a risk of unfair dismissal if the employee has been employed for the relevant qualifying period, an employer can terminate the employment relationship and stop paying that individual. Similarly, if a shareholder is a director and the director's service agreement is silent regarding removal, or again where such an agreement does not exist, there is a prescribed statutory procedure under the Companies Act for removing directors. So that deals with the issue of employment. The position regarding the ownership of any shares is, however, a discrete matter. And with only model articles in place and in the absence of a proper shareholders agreement to govern the relationship between shareholders, dealing with any shares held by the individual employee can often be a complex and time-consuming process. Under the Model Articles of Association, there is no automatic power to compel a shareholder to transfer shares upon termination of their employment. This problem is often particularly acute with director shareholders or founders, as they regularly hold a significant shareholding in the company. Consequently, if there are no express provisions to govern shareholder leavers, then there will be nothing that the company can do to get the shares back other than to negotiate a sale of the shares or a company buyback of the shares. Now, this in itself can be a difficult process to navigate. Often emotions are running high and the exiting shareholder will be less inclined to act reasonably towards their ex-employer. And where the shareholder knows they cannot be forced to sell, they may take the opportunity to hold out for what is in reality an overinflated price. It's also important to remember that a limited company that wishes to buy back its own shares must comply with Part 18 of the Companies Act. This means that any company purchase must be funded by way of payment out of capital, and because this is potentially prejudicial to the interests of the company's creditors, the company must follow a prescribed procedure. The legislative framework and associated timetable around a company's share buyback is strict, and the intricacies of the legislation are easy to fall foul of. Another important consideration to bear in mind is the retention of shareholder rights. Now again, this is important because in the absence of any agreement to sell their shares, the ex-employee or director will retain all of their shareholder rights. Now, depending on the classification of the shares, this could include an entitlement to dividends, a share of capital where there is a sale, and of practical importance, voting rights. The retention of voting rights, along with the right to inspect records of minutes of board meetings and copies of all shareholders' written resolutions, etc., can cause significant problems regarding the day-to-day running of the business, particularly when the exiting shareholder is left on bad terms. So, what then is the solution to prevent these problems from arising? Well, thankfully, the solution is relatively straightforward, and that is to ensure that you have a proper framework in place to avoid shareholder disputes. This requires investment in bespoke corporate documents that specifically cater for situations when shareholders leave and provide appropriate mechanisms to govern disputes between shareholders. This documentation does not have to be overly complicated, but it does have to integrate with the overall commercial strategy of the company and be in place prior to the shareholder exiting the company. One area that an appropriate shareholders agreement should necessarily incorporate is the concept of leavers. Leavers are typically shareholders who have been directors or employees of a company but have left their respective positions. The shareholders agreement should contain provisions that differentiate between good leavers and bad leavers, and these should be accompanied by appropriately robust definitions within the body of the shareholders agreement. Now, it's often difficult to cater for all potential situations that may arise when initially drafting the shareholders agreement, and for this reason, any definitions should be drafted so as to give a certain degree of discretion to the company as to which category of leaver an individual falls into. The rationale that underpins this distinction is that good leavers may be allowed to keep their shares, or they may be required to sell them back to the company in accordance with a prescribed mechanism and/or independent valuation. Examples of good leavers can include those who leave the company for reasons of ill health or redundancy. Furthermore, to recognise a prolonged period of sweat equity, the definition of good leavers within a shareholders agreement could also include those who choose to resign after completing a certain number of years' service. Conversely, bad leavers are often defined as those who resign within a short period of time, or those who breach the terms of their service agreement or the shareholders agreement. These bad leavers will then be required by the terms of the shareholders agreement to sell their shares back to the company for the face value of the shares or the price paid for those shares if lower. The rationale being that bad leavers should not benefit financially from their conduct. There are, of course, a multitude of other considerations to bear in mind, and it would take too long to go through all of them in this video. But some of the key considerations to bear in mind include the ability to pay shareholder leavers in instalments. Now, as I said at the beginning of this video, startups may have limited amounts of working capital. Therefore, there may be situations where it's appropriate to make any payments for shares in instalments. In some situations, it may also be tactically advantageous for the company to stipulate that its obligations to pay those instalments is contingent upon the seller complying with certain conditions. This could be designed to protect intellectual property and any other company assets, and in such a situation, the company's obligation to continue to pay the instalments could be predicated upon the seller continuing to comply with any relevant restrictive covenants. Such an approach would not only help with cash flow, but would also ensure the exiting shareholder complied with any post-termination restrictions. Conflict between documents is also an important consideration. The law recognises the distinction between shareholders and employees, and this distinction means that typically separate agreements are used to govern these relationships. And one issue that commonly arises is that different definitions of leavers are contained in the shareholders agreement and director service agreements. And difficulties can arise when these terms conflict. And it goes without saying that any conflict in terminology should be avoided. Our preferred solution is that shareholder agreements and employee and director service contracts should be drafted at the same time so as to ensure a homogeneous approach. It can also be specified within the drafting that one agreement takes precedence, this usually being the shareholders agreement. Another topic to consider is the value of the shares held by the shareholder leaver. Because if the shareholders are in agreement that if one of them stops working with the company as an employee, their shares will be bought back by the company, the question that then always arises is, well, how much are the shares worth? With listed companies, the share price is relatively easy to figure out. But for unlisted companies, there is no open market for those shares, and therefore the price can be more difficult to satisfactorily define. The parties may be in a better position to pre-agree what price will be paid for those shares early on in the relationship, rather than later on when the relationship may have broken down. This may include a fixed formula for calculating the price, or agreeing that they will be bound by the opinion of an independent expert. Working out fair value can include deciding if there is to be a discount where the shareholder leaver controls a minority shareholding, the rationale being that small shareholdings are worth less than large shareholders due to the lack of influence over shareholder voting. But no matter what approach is ultimately adopted, the aim of the shareholders agreement is to set out the final position with sufficient particularity to ensure that whether they are the seller or the buyer, all parties are clear about how the issue will be resolved. Who then gets the leaver's shares is another question to be borne in mind. A good shareholders agreement also sets out who is to be offered the right to acquire the leaver's shares. There is usually a procedural order of priority. By way of example, it could be decided that shares are first offered to the company, and if refused by the company, then they are offered to the largest shareholder. If the largest shareholder then refuses to buy the shares, they are then offered to the second largest shareholder, and so on. Now, this doesn't have to be the case. It's perfectly possible to provide that all shareholders have the opportunity to acquire shares pro rata in accordance with their existing shareholdings. All these things can be negotiated. If, however, the company or the remaining shareholders do not have the cash or the desire to buy the shares of the good leaver, the remaining shareholders can always elect to allow the good leaver to hold on to those shares. The skill in negotiating and drafting any shareholders agreement is in ensuring that all shareholders are happy with the position. So what conclusions can SMBs draw from this area? Well, I firmly believe that it's best to adopt the old adage, hope for the best, but prepare for the worst. A good shareholders agreement doesn't have to be overly complicated or unduly onerous, but what it should do is provide clarity between the parties. Adopting a shareholders agreement also encourages people to discuss matters openly at the beginning of any business relationship. I personally believe that it's a sensible and healthy thing to do this, as it encourages openness between the parties, and it also prevents people labouring under any misapprehensions, which can lead to a breakdown in trust further on down the line. That initial investment in a bespoke shareholders agreement that properly reflects the needs of the business can save a huge amount of time and expense further on down the line, and is something that all businesses should invest in. Well, I hope that you found today's video insightful. There is an ebook that accompanies this video, and you can download by clicking on the link below. Finally, please let us know in the comments section below if there are any particular topics you'd like us to deal with, so that we can make our content as useful as possible.